As promised, we're now joined by Todd Lutsky from the law firm of Cushing and Dolan for Ask Todd. This segment is your chance to ask Todd your questions about your estate plan. So, if you've got a question about your estate plan or about your lack of estate plan for Todd Lutsky, our studio line here is 888-205-2263. That's the number to call to ask Todd your question on the radio. Again, it's 888-205-2263. 2263, so get all queued up and we'll get to your calls as soon as possible. Mr. Lutsky, it is good to see you today. How are you?
Oh, nice to see you. I'm doing well. Can't complain.
I'm struggling a little bit.
Uh-oh.
I shocked myself yesterday when I was playing with an electrical outlet.
You were.
And so my dad actually grounded me until I could learn to conduct myself properly.
That's very good. That's good parenting.
Yeah, so
good parenting, I think.
I know, they're still parenting me. So let's talk a little bit about estate planning as it relates to protecting assets from the cost of long-term care.
Yeah.
Let's say that someone does fall into that category where they have not put together an estate plan.
Yeah. Yeah.
And let's say that something happens to them and they have a long-term care situation.
Sure.
What are their options if they're heading into a nursing home or other type of long-term care facility today and have not done an estate plan?
And you know, I'm going to add to that just a little, Chuck. I'm going to say it could be somebody who didn't do an estate plan or somebody who did, but you remember, we don't put all the assets into the trust. So there's always like
Sure.
IRAs and things outside the trust anyway. So you're going to always have something outside the trust. But your point is well taken. Even if you have not done it, if you've done planning, yes, there could still be a need. But if you've not done planning, you know, what are your options? Well, of course, the one option everybody thinks of on their own, write the check. $15,000 a month.
Is that what the cost is today?
Yeah, it's about that. Depending, you know, it could range. You know, it might be 13 to 15 or something like that. 12 to 15. It depends on where you are and what kind of facility. But yeah, you know, so write the check. Now, that's an option. To me, that's not an option, but people think it's an option.
Sure.
So what I think are options are, one, you really need to understand what assets are countable, what assets are not countable for Medicaid eligibility. That's what you're thinking about here. If you're going in the nursing home, you're saying, I don't want to pay $15,000
Which list is
a month.
shorter, countable or non-countable? No, I'm serious. Which list is shorter?
The shorter is the short list is what is non-countable.
What's non-countable?
So what's non-countable would be your home. So if your primary residence is your home and your spouse is living there, it's non-countable and non-lienable. That's nice. They let you keep the house own, and there's no restriction on it at all. But if you're single, the house is non-countable, but it's non-countable provided you check a box that says, I'm going to return home, and that house is not worth more than, and this number, it increases each year. I believe it's somewhere around $985,000 now. If it's worth more than that and you're single, it's countable. You're just going to be denied Medicaid. So sometimes the answer to your question isn't always so easy.
Sure.
But
yeah.
But in that case, it's the home would be the one that you think of as non-countable if you're married, non-countable if you're single. But the difference is that value limitation. And with a single person, the house is lienable. But with a married couple, if the spouse is living there, it's not lienable or countable. So it's a home run. But it's not really a home run because if the healthy spouse gets sick and goes to the nursing home, now you're back in that countable world again.
Back to square one.
Yeah. But you got to learn what is and what is not countable because it's just amazing what you can do last minute.
Talking with Todd Lutsky from Cushing and Dolan. If you have a question for Todd about your estate plan, this is your chance to ask him. The number is 888-205-2263. When we come back from our next break, we're going to be going right to your questions with Todd Lutsky. So again, that number is 888-205-2263. That's our studio line here. So you can ask Todd Lutsky your questions. Again, 888-205-2263. Quick break, and then right to your questions with Todd.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
All right, now it's time to go right to your calls with Todd Lutsky. No time wasted. Let's go first to Tucker. Is this Jay or Judy on the Cape?
Jay. My handwriting's terrible.
Okay, we got Jay on the Cape. Jay, you're on with Todd Lutsky. What's your question?
Todd, about 5 years ago, you did an irrevocable trust for me and my wife,
Okay.
and we put the house in the trust, and then I got a small construction company. It's an LLC, and you advised us to put that in the trust also.
Excellent.
Which we did.
Good.
Okay. Now, my question is, can I take money out of my company and put it and buy a CD and then put it back in without restarting the clock on it?
You absolutely can. This is a really great question to show the flexibility and how these irrevocable trusts really do not restrict your life. So if you have a company, I'll just call it an LLC for now, the LLC construction company, you are the manager. So you operate that company, you collect money into that company, you pay the bills out of that bank account in the name of the company. And then the shares of the company are owned by the trust. So this company has been in the trust for more than 5 years. So the company itself is the asset, is the entity that's protected because the owner of the company is the trust. So that's protected long 5 years ago. Now, as the manager of the LLC, you have profit, money kicking around in that account. You want to make a distribution from that account, which you can do as the manager, to the shareholders. Well, the shareholders is the irrevocable trust. So wonderful. The money now goes into a bank account in the name of the irrevocable trust, not resetting a clock, not starting anything new. You're just making a transfer of an asset from the entity to the trust, which is the shareholder, which owns the stock. And then you can take the money from that trust and open up a CD if you want, or however you want to invest it. I'm not here to tell you how to invest it. But if you choose a CD, just open up a bank account in the name of the trust and make it a CD and leave it in the name of the trust. And you have never reset the clock, and your money is still protected and it's invested the way you want. Folks, this is a wonderful way of understanding how flexible the irrevocable trusts are. However, not everybody is always as wise, perhaps, as Jay, who has done his planning in advance. And so what we run into sometimes is people who have procrastinated, not got around to doing it. They're afraid of inflexibility or rigidity or whatnot, which, of course, was just disproved by Jay's question. But if you don't do your planning and you find yourself in a nursing home, whereas if Jay does, it's going to be protected, those assets are safe, some aren't. Whatever's not in the trust is not protected. How do we learn what to do last minute, folks? That happens. Well, this guide, Long-Term Care Planning for Procrastinators this month, talks about how to treat assets. What's countable? What's non-countable? How is a house primary residence treated differently than a vacation home? Treated differently than a rental property? Treated differently than an investment account, right? Learn what's countable, what's not countable. Don't just write the check. Call, get the guide. It's 866-848-5699, or go to our website, legalexchangeshow.com. Download it there. Again, 866-848-5699 or legalexchangeshow.com.
Stay on the Cape here and go to Debbie on the Cape. Debbie, you are on with Todd Lutsky.
Hi, Todd.
Hello.
My husband and I, this is a second marriage for us, and we did, a few years ago, we did our estate planning, and our lawyer advised against us putting our house in our children's names or a trust to protect it in case of nursing home situations.
Wow.
Now, I just went through this situation with my parents, and their house was in the children's name, so that wasn't protected at all. So we went through the process of Medicaid with my father, no problem. But now I'm wondering, now going through this situation, going through the process, I'm thinking that this was not probably a great idea for us.
I can't. How old are you guys?
We're in our late 60s.
So this is the absolute perfect age. I know nothing about your plan yet, again, or how many assets you have or anything, but if you have the amount of assets that make sense to protect them from the cost of long-term care, and that's a concern of yours, these plans are always driven by the client, right? So if that's an objective of yours, I would be scratching my head to this attorney as to why on earth I would not put it in an irrevocable trust to protect it from the cost of nursing home care. I do fully agree with the lawyer's assessment of not transferring it to your kids. Please don't do that. In fact, I wouldn't do it. I wouldn't help you do it. That's how strongly I feel about that, because if you give it to the kids, you're sticking your children with the capital gain built into that house. And it's not owned by you anymore. Yeah, it'll be protected from the nursing home in 5 years, but you've lost all your rights to live there. You've lost your rights to sell it, to get the proceeds. You've lost a lot of capital gains tax benefits. Nothing good comes from it. The kid gets a divorce. That's not helpful. Putting it in a trust, irrevocable trust, you don't have any of those problems. You can live in your house. You can sell your house, buy another house. Look at Jay. Jay called. He's got a business in the trust, and he's running the business just fine. It's been in there for 5 years. No complaints. You can, like I say, sell and buy another house without resetting the 5-year clock. I could go on and on, Debbie, but I got to tell you, I would consider a second opinion with this particular lawyer and maybe learn about how these trusts work and decide for yourselves once you fully understand how they work, whether it's right for you. But I have a strong suspicion that it probably will be right for you guys.
Todd, I've got another one queued up for you here. Let's go to Mary in Buzzards Bay. Mary, we only have about a minute or so you have to be a little bit quick with your story.
Okay, sure. So my mom's in a nursing home, and we are paying the $14,000 a month. Mm-hmm. Right now, she's got the cash, mm-hmm. and that's going to be gone in about a year and a half, roughly, maybe mm-hmm. 2 years at the most. Mm-hmm. Her name was off the deed of her property, her primary residence, but 2 siblings passed away. Unfortunately, my parents did put their property in our siblings' names, all of us. Mm. And what happened is when those 2 siblings died, 40% went back to my mom's ownership. Oh. So now 60% of that house is protected. 40% is not, obviously.
Right.
And so it's in a wealthy community, and we're considering renting or selling. We're trying to figure out what's the best.
So let me give you the quick answer. I think I have a picture. I just want to make sure I can answer your question. So 1, she's in the nursing home. Number 1, with me, if I'm guessing, she's got about $200,000 based on what you told me she has to last, and 40% interest in a home. If it were me, I would say you should seek out a lawyer about getting on Medicaid right now. First of all, there's no reason for you to spend $14,000 a month going forward. Period. We can protect the $200,000 very likely either through an annuity investment or a pooled trust. Again, it's a special annuity, but you could do that. And I think the home we can protect because it was her primary residence. So I don't think you're going to lose the 40% either if you want to keep it. I can talk to you about what the benefits are of selling it. I don't see as many, but you could do it if you like. My advice, though, and I know we didn't have a lot of time, is don't keep writing that check. That's what this guide is all about. Just seek out an elder law lawyer now and see about how you can get on Medicaid.
Todd Lutsky, thanks for the time today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.